Welcome to Courts Today by LiveLaw, and I'm Devojit Das. From constitutional challenges to bold affirmations of secularism, and from tax rates to animal welfare, the courts have had a busy day. So, let's begin. The Supreme Court has stayed the operation of certain provisions of the Waqf Amendment Act of 2025 while refusing to interfere with its registration requirement. In the case, the court took note of challenges to controversial provisions, particularly the clause requiring proof of practicing Islam for 5 years before being allowed to be a mutawalli, and provision empowering district collectors to decide disputes relating to Waqf properties. A bench headed by the Chief Justice observed that these provisions raised serious constitutional concerns and stayed their operation until further hearing. However, the requirement of registration of Waqf properties was not interfered with, since the court felt it was part of the regulatory mechanism and did not violate any rights. The matter will continue to be heard, but for now, the more contentious aspects of the amendment have been put on hold. In another important development, the Supreme Court has issued directions to ensure humane conditions in beggars' homes across the country. The court took cognizance of reports highlighting overcrowding, unhygienic conditions, and lack of medical facilities in such institutions. It emphasized that even individuals in beggars' homes are entitled to dignity and basic human rights under Article 21 of the Constitution. The bench directed state governments and the union territories to ensure proper sanitation, adequate food, healthcare facilities, and even recreational opportunities in these homes. It also stressed the need for periodic inspections by independent committees to prevent abuse or neglect. With these directions, the court has sought to make sure that these institutions serve as spaces of rehabilitation rather than punishment. The Supreme Court has also upheld Coal India Limited's dual pricing policy, which imposes a 20% price hike on non-core sector industries. In the present case, the court examined Coal India's 2006 interim policy, which classified industries into core and non-core sectors. Core sectors like power and steel were shielded from price hikes due to their essential role in public welfare, while non-core industries producing non-essential goods were asked to pay more. Non-core companies had challenged the decision as arbitrary and discriminatory, and the Calcutta High Court had earlier ruled in their favor. The Supreme Court reversed that judgment, holding that the classification was reasonable under Article 14 of the Constitution. The court stressed that protecting core sectors from price rises prevented cascading effects on essential goods and services, while hikes on non-core industries had minimal public impact. It further clarified that the coal linkage system was a policy decision and not a statutory right, meaning non-core companies could not claim entitlement to uniform pricing. The court found that the 20% increase was not profiteering but a legitimate measure to sustain Coal India's operations. Moving on, the Delhi High Court has upheld the validity of surprise searches under Section 132 of the Income Tax Act. The case involved a family whose lockers in South Delhi vaults were searched by the Income Tax Department without prior summons or notice, leading to seizures of valuables suspected to be undisclosed assets. The family argued that such action violated the requirement of notice under Section 132(1)(a) and lacked the necessary reason to believe. The court disagreed, ruling that the clauses under Section 132(1) A, B, and C are mutually exclusive, and satisfying any one of them is enough to justify a search. Since Clause C, which requires reason to believe that someone holds undisclosed assets, was met, the absence of summons under Clause A did not invalidate the action. The court found that a preliminary inquiry revealed suspicious circumstances justifying the search and accordingly dismissed the petition. The Karnataka High Court has delivered a significant ruling on secularism in public life. The court rejected petitions against the state government's decision to invite writer Banu Mushtaq as the chief guest for the Mysuru Dashera celebrations. Petitioners, including BJP MP Pratap Sinha, argued that since Dashera is a Hindu festival, the chief guest must be from the Hindu faith, and they also raised objections to Mushtaq's past remarks. A bench of Chief Justice Vibhu Bhakru and Justice C.M. Joshi dismissed the pleas, holding that India is a secular state and that invitations to state functions cannot be restricted by religion. The court stressed that Dashera, when organized by the government, is not purely religious, but also a cultural and public celebration. It further clarified that no fundamental rights of the petitioners were violated, nor were the rights of Hindu religious institutions under Article 26 affected. Turning to another Supreme Court case, the court has accepted the report of a special investigation team into the acquisition of animals by Vantara, the Green Zoological Rescue and Rehabilitation Center in Jamnagar. The SIT, led by former Supreme Court Judge Justice Chilameshwar, found that Vantara's acquisitions, including elephants, were within the framework of regulations and involved no foul play. The petition had alleged irregularities in the transfers, but the SIT's independent inquiry found otherwise. During the hearings, Solicitor General Tushar Mehta and Senior Advocate Harish Salve argued strongly against disclosing all records publicly, stressing confidentiality and warning against speculation. The Supreme Court agreed that the report was comprehensive and independent, and with no evidence of illegality, there was no need for further doubt. With this, the court has closed the chapter on allegations surrounding Vantara's acquisitions. The Supreme Court has also clarified the scope of the POSH Act. The court held that political parties do not come under the ambit of the Prevention of Sexual Harassment Act. The petitioner had argued that entering a political party was akin to an occupation, and therefore parties should be treated as workplaces under the law. Both the Kerala High Court and now the Supreme Court have rejected this claim, holding that membership in a political party is voluntary and does not create an employer-employee relationship. The court observed that while sexual harassment anywhere is unacceptable, the POSH Act's machinery is limited to workplaces and cannot extend to voluntary associations like political parties. Other remedies under criminal law remain open, but POSH cannot be stretched to cover party memberships. And finally, in a move to modernize judicial communication, the Kerala High Court will soon begin using WhatsApp to share case listings and updates with advocates and litigants. This step is aimed at improving efficiency and reducing confusion around scheduling, especially in cases where urgent hearings or last-minute changes occur. By sending real-time updates to registered mobile numbers, the court hopes to bring communication gaps that often arise through traditional notices or emails. This initiative is part of the judiciary's broader efforts to embrace digital solutions, including e-filings and virtual hearings, that marks a practical step towards making court processes more accessible and user-friendly. That wraps up today's roundup of major court developments. This has been Courts Today by LiveLaw. I'm Pvt Das, and stay tuned with us for more updates from the courts across India.